He has numerous other talents, which we may be fortunate to experience in this talk, and I think many of you know what that means. And for those who don't, you might find out. Bill.
Thank you, Ann, and it's a great pleasure to be with you, as it always is. You are my best audience, even better than my wife and children. So today we're going to talk about some of the same things we've talked about before, but a little bit further down the road. So let me begin with my favorite topic, the right to be forgotten. So we're going to revisit that again. So did the European Court of Justice forget something? So on September 24th, they issued an opinion ruling that the European Union's privacy law, which includes a right to be forgotten, cannot be enforced beyond the boundaries of the European Union. Thus, the right to be forgotten is restricted to the EU and can't be enforced in the United States or elsewhere. So that was a pretty clear holding. 9 days later, the European Court of Justice ruled that Facebook can be forced to delete content worldwide. The court held that individual countries can order Facebook to take down posts globally. So why the different results? So let me go back and say what, in a little more detail, the September 24th opinion, which involved Google, was about. So in that case, the French privacy agency had issued an order requiring Google to remove certain deleterious information about an individual pursuant to the right to be forgotten. And the court, the European Court of Justice, then considered the appeal by Google against that French privacy agency decision. And the decision by the European Court of Justice was intended to prevent international disputes over the reach of the EU's laws. The court said that Europe could not impose the right to be forgotten on countries that don't recognize that law. So there was also a companion case in which the court held that individual privacy rights must be weighed against the public's right to know about some categories of personal information. That case involved a challenge to, or a demand for Google to remove information about individuals' religion or race or national origin. And so the court said, well, that could be something that a local court or a privacy agency could order, but only within the European boundaries, and you have to balance the public's right to know against the private's right to be forgotten. Okay, next case, October 3rd. So on October 3rd, the European Court of Justice held that individual countries can order Facebook to take down photos or videos or audio posts globally. So why is there a difference between the September 24th ruling and the October 3rd? Not because they forgot that they'd ruled a different way, but because courts have broader powers if the content is found to be defamatory or otherwise illegal. So in this case, the October 3rd case, there was social network comments calling a particular Austrian politician a traitor, corrupt, and a fascist. And a court case ruled, that is a lower court, had ruled that these were defamatory comments and that therefore Facebook was obliged to remove them, not just in the EU, but but globally. And the European Court of Justice said, yes, they could do that because these were defamatory statements. Now, that begs the question as to whether or not such an order would be enforceable in the United States. And you may recall last year I reported on a Canadian court order requiring Google to take down some information. They challenged it in California State Court, and the California court said, oh no, that's a Canadian order. You can't enforce that in the United States. In fact, Canada's not even a country. No, they didn't. I'm sorry, they didn't really say that. Okay, pause. Now let's switch to the United States, speaking of California. So California has adopted a privacy law. And in this new privacy law called the Consumer Privacy Act, or California Consumer Privacy Act, CCPA, that it's really the toughest privacy act in the United States. And it does include a right to delete. It's not called a right to be forgotten, it's called a right to delete. And it's kind of like the EU right, but not really, because it's California. The right to delete in this new California statute grants consumers the right to request deletion of their personal information. Now, I emphasize that personal information phrase because unlike the EU right to be forgotten, which would apply to third-party entries or other kinds of information, the CCPA's right is limited to a request that the business delete personal information about the consumer which the business has collected from the consumer. So it's actually very limited. It's not some third person saying, oh, you're a traitor or you're a fascist. It's if you report that you're not a fascist and someone publishes the fact that you are a fascist based upon what you told them, you say, wait a minute, you have to take that down because that's not what I said. So it's limited, but it's a step further towards privacy rights than America as a country has traditionally followed. And so this whole privacy right world is beginning to heat up more and more. And interestingly, spurred by the California Consumer Privacy Act, U.S. tech companies, Googles and Facebooks and others, have begun to push, amazing, for federal legislation on privacy. Now, until the California statute had come along, they were quite opposed to any federal legislation. Oh, no, we don't need that. We'll police ourselves. But in fact, they're now saying, oh, it would be much better because we don't want to be subject to 50 different privacy regimes countrywide. It would be better if there was just one. But of course, their idea of a federal privacy act is one that has essentially no teeth whatsoever. So that they would not prefer the California model be adopted, or certainly not the EU model, by the feds. So at the same time, there are consumer organizations in the United States that are saying, hey, that California statute sounds pretty good to us. Let's get it adopted in South Carolina or New York or wherever. So these are pushes and pulls in this area. So what do I see as some significance to libraries about what I've just been talking about? If there were to be a global takedown order, it would conceptually have some effect on a library because of the databases that it has. But normally it's the database company that's the one that's the target of the takedown order, and so they're supposed to respond. You're not supposed to have to go in and peel out pieces of information from the databases that you're handling. The second is that if a library or other institution in California is in California, then you may have some responsibilities under the CCPA if there is a request based on the right to delete. And there could be personal information in your files about individuals that you may have to take out. Okay. So turning to the ever-popular subject of pornography, I reported last year on a case, Pornography is Not Education, quote unquote. That's the name of a group, acronym PINE or PINE, versus EBSCO and the Colorado Library Coalition, or Consortium, excuse me. And in that case, a group of Colorado parents claimed that the EBSCO database that a lot of schools had was actually an access point to pornography, and that therefore it was a violation, and therefore California Library Consortium and others should take out EBSCO. And the theory was that if you went into the EBSCO database and you plugged in some kind of search, you would get a pornography back. Now, I didn't personally try this. At least in any reportable fashion. But others did in the library communities, and they said they were unable to produce the kinds of results that supposedly the plaintiffs had achieved. And so the case was starting to go forward, and there was a little filings back and forth. And then all of a sudden, the plaintiffs, the parents, dropped the lawsuit. And they explained that the reason that they had dropped the lawsuit was because Colorado, which is where this case was pending, has a law which says that if you bring a lawsuit and you lose the lawsuit, the prevailing party can apply for attorney's fees and costs, and the court can grant that if they believe that the claims or that were made were frivolous, groundless, or were prosecuted in bad faith. And they said, oh, this is a really unfair law, and we're going to take our argument somewhere else. So they dropped the lawsuit, which was good, because they should never have been brought in the first place. But it had a cost. I mean, it had a cost to the Library Coalition to defend the case, and also all this publicity actually led to, I think the estimate was like 150 libraries dropping the EBSCO database. Well, that's kind of destructive of free speech and a number of other things, and it was totally unjustified. But anyway, that happened, and the Thomas More Society, which is it's kind of an odd-sounding name, but that's actually the name of a nonprofit law firm dedicated to fighting abortion and other kinds of things, including pornography. They say, well, they're going to find other states to bring this lawsuit in. So we'll see what happens. Okay, ResearchGate. You will remember that last year, the American Chemical Society and Elsevier had sued ResearchGate. Everybody knows what ResearchGate is, yes? Yeah, good, okay. So they got sued, the ResearchGate got sued in federal court in Maryland for copyright violations, alleging massive infringement of peer-reviewed published journal articles. So what's the status of this case? So ResearchGate defended, claiming, this is their defense, that when the plaintiff's publications appear on defendants' websites, it's because a co-author of that paper had given permission to ResearchGate to publish it. And that was okay because these co-authors supposedly had not signed the agreement with Elsevier or American Chemical Society or whoever the publication was, they hadn't signed their rights away to the publication. So therefore, it was okay for ResearchGate to publish it because they had gotten these co-authors, these unsigned co-authors, to upload the papers. Okay, maybe that could be true. And as part of their defense strategy, ResearchGate filed a motion to require the American Chemical Society and Elsevier to basically serve a complaint on all of the co-authors of all of the papers because they have a right to know about it and have their rights defended, et cetera. And so this was a motion which would have very much disrupted the case and made it very difficult for the plaintiffs to go forward. So the court heard evidence on this, and at the conclusion of this hearing on this motion, the court said, well, ResearchGate had not offered even one specific example of a co-author who uploaded an article believing that he or she had the right to do so. They said, well, oh yeah, there's a box that you can check when you upload something, and the box says, I have the right to upload this. So I said, well, that's not enough. You've got to actually have a person. You know, Mary Jones, professor at such and so, who is the co-author of this paper and who believed that she had the right to upload this document. But they didn't name a single one of these people. And so the court found that the defendant, ResearchGate, had not met its burden to prove that evidence in the record cast doubt upon the validity of the publisher's copyrights. So accordingly, the case is going to go forward. We'll see what happens. But this particular opinion casts some doubt on the validity of ResearchGate's defense. Oops. Here we go. So, and now it's time for animal law. When does one duck-shaped pool float infringe copyright on another? So let me just ask this question to the audience. What do you call a duck that steals? Anyone? Yes, sir. What is the answer?
Robber ducky?
Yes! Robber ducky, you're the one. Thank you so much, sir. Now, in this particular case, there was a company called the Great American Duck Races, Inc., which had made quite a bit of money and quite a bit of success selling large quantities of small little rubber duckies for fundraising races. Anybody ever participated in one of these? Yeah, you know, you pay $10 and they give you a duck and you put the duck in the water with all these other ducks, and then they open the sluice gates and all the ducks float downstream, and the first rubber ducky that gets to the end, whatever the number of that is, that person wins. So that was, you know, a perfectly effective little kind of money-making device. But then they decided, people love these rubber duckies so much, let's make a giant rubber ducky that someone can get into and float, maybe not in a race, but can float in a pool or whatever. So they made a giant rubber ducky. And then somebody else, this is the Great American Way, looked and said, wow, those guys are selling rubber duckies hand over fist, giant ones. Why don't we make a giant rubber ducky? So the owner of that company gives one of the Great American Duck Races giant floats to a designer and says, make me one, but that's not the same. I want you to make it that's different. So the question is, was it different enough? Oop, keep pushing the wrong button. There we go. Okay. So this fine piece of American creativity is the Great American Duck Races duck. and a little, this is the cover of the box, and there was a little thing that says model not included. And so this was the plaintiff rubber ducky. And here's the model is again not included. This is the challenged rubber ducky. And so the question is, you can see them there. There's number one, and there's number two. Are they so similar as to be a copyright violation? So what was the result here? The court held that Great American's copyright cannot prevent others from depicting yellow ducks with a bill, wing, and a tail and a crest on the head. Nor can they protect the idea. Remember, copyright doesn't give you a right to the idea, only the expression of the idea. So they can't protect the idea of a duck float wearing sunglasses. So Great America is entitled to protection only for the way it expressed the idea of a duck wearing sunglasses. And the court concluded there was no infringement here, pointing to key differences, which I will just illustrate for you. The sunglasses in this are separately inflatable. So you got to blow twice, one to blow up the duck and then one to blow up. And here, these are not inflatable sunglasses, they're painted on sunglasses. And bridge, you may not have noticed, you see how subtle you have to be in this? This one has a double bridge. You see between the two parts of the sunglass, there's a double bridge. But these guys only have a single bridge. And it was a little hard to tell from the two pictures, but the duck number one had a very black sunglasses, and the one that was challenged was not really solid black. So you can learn a lot from this case. And now I would like to discuss music copyright. You probably remember that 6 years ago, Katy Perry, a gigantic hit pop star, had a big hit with her song Dark Horse. And of course, you will recall, if you remember seeing the music video, that it featured Katy Perry dressed as Cleopatra floating down the Nile. Now, you may wonder what that has to do with Dark Horse. Well, you see, Cleopatra, who was kind of a tease, was singing how she was going to come at you like a dark horse. And that was the link to the title of the song. And this song included a rap overlay for the last third or so of the song by Juicy J. No doubt many of you have albums by Juicy J, the rapper. But he comes out and he sings a rap song on top of her vocalization. So that was 2013. Now, a year later, in 2014, Marcus Gray, another rapper, and two of his co-writers, sued Katy Perry and her production team for allegedly infringing the copyright on one of Marcus Gray's songs, which apparently hardly anybody had ever heard of, but it was called Joyful Noise, and it was a Christian rap song. And he was making a joyful noise about Christian topics. And so they claimed that she had heard this song online, which apparently was the only way you could get it, in 2008 or thereafter, and unintentionally and subconsciously copied it to make her own hit. So take a quick listen. Here's the two clips from these songs.
You should know what you're falling for. Baby, do you dare to do this? 'Cause I'm coming at you like a dark horse.
street dumber. Be careful, try not to lead her on. Shorty heart is on steroids, cause her love is so strong. You may fall in love when you meet her. If you get the chance, you better keep her. She's sweet as pie, but if you break her heart, she turns cold as a freezer.
Woo! Does that get your blood pumping or what? You feel like a racehorse, right? Okay. So now here's Joyful Noise.
You know what it is? I love it.
You hear some repeated notes there?
Yeah. I love it. Let's talk about it. Your boy's been a Christian quite a few years. Victory and faith, but I failed in my fears. I heard a lot of words that have tickled many ears. That's why I praise God for the word that we adhere. The word became flesh, lived for 30 years. Died at 33, but after days reappeared. Jesus Christ, anointed one, ascended in the ear. Or you could say the air, where the Father made him heir.
Okay. Now, you can see why there'd be a lawsuit between those two, right? So the rap artist, that is Marcus Gray and his people, pointed to the repeated lines of notes, or ostinato, as Boris Karloff would say, underlying the rap words, and asserted that even though the notes in the beat might sound simple, the beat itself is unique and was entitled to copyright protection. Katy Perry's defense team argued that there was no evidence of copying, that is, no evidence that she'd ever heard this record or anyone else had ever heard this song, and that the musical phrase in contention is a simple run of repeating C and B notes that cannot be copyrighted. C, 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 B, 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 C, C, C. I'm a rap star, right? But amazingly enough, a California jury, did I say it was a California jury? Bought the ostinato theory. Wow, no one's ever done that before. And found that there had been an infringement of Joyful Noise and awarded Marcus Gray $2.8 million in damages, or 22% of the profits of the song. And Perry's lawyers, not surprisingly, called the verdict a travesty of justice and vowed to take an appeal. So here's my take on this copyright battle with thanks, or maybe no thanks, to Little Nas X. Okay, we're gonna get ready. We're gonna go warm up here now. Till they can't no more. The joyful noise on the old town road. There's a one in the federal court. They got the lawyers in the back. All books are attached. Things are looking black. Got a mood to track a match. Singing about dark horse. Wow, her voice is hoarse. Out on a race course. You ain't in her source now. Never heard. Don't nobody give you nothing. Never heard your nothing. Riding on a Nile boat, dressed like Cleopatra, using common 8 notes. That tune's just a mantra. Her life is a movie, singing songs so groovy. Why would she steal that beat when she'd be a copy lead? Don't nobody never heard you. Don't nobody copy nothing. Never heard your nothing. If I wanna sing the chorus on the old town road, they gonna sue till they can't no more. A joyful noise on the old town road, unless they're reversed in the federal court.